Thanks for staying with us. A ruling declaring some regulations relating to the social relief of distress grant unconstitutional and invalid has been hailed as a victory for the country's most vulnerable by some advocacy groups. Remember, there were concerns that some of the updated regulations were excluding some of the beneficiaries. Let's speak to Siyanda Baduza, who's the basic income researcher at the Institute of Economic Justice, about this further. Siyanda, good evening to you, and thank you so much for your time. There were concerns, by some of the advocacy groups, especially when you looked at some of the, updating of the regulations that were excluding some of the beneficiaries. How far does this ruling go in order to remove the barriers, especially those that have been put in the way of the people trying to access the SRD grant?
Good evening. Thank you for having me. So like we've long argued, I think the story of the SRD grant has been a story of government continuously undermining its own policy. So we know, for example, that according to government's own estimates, that there should be around 18.3 million people who should be eligible in South Africa. So that should be the number of people who are living or who earn under 624 rands a month, but actual approval numbers have been far below that, less than half. And we know that the reason for that is because of the regulations that were implemented, because prior to the regulations, average numbers were around 10, 11 million in, say, March 2022, and the month immediately after the implementation of the regulations, the numbers fell drastically. So this that was the basis of the court case, was to challenge a lot of these procedural barriers that we argued led to a lot of people being unfairly excluded from the grant. So things like online-only applications, which discriminate against people who don't have smartphones. And the ruling goes far because the court essentially agreed with us on all of the issues that we found, and found that a lot of these regulations are unlawful and unconstitutional.
And has the ruling said, how then do you begin to also address the issue of the threshold, especially when it comes to insufficient means, because that has also been one of the contentious points?
Yes, so on over and above the procedural barriers themselves, it was also something else we were challenging was the value and the means threshold itself. So the means threshold, we know, for example, was introduced in 2022, and then it was set at the food poverty line for 2021, which is 624 rands, which has since then been adjusted to, I think it's almost 800 rands. And the issue with it is, then it was linked to an objective measure of poverty, but because it hasn't been adjusted for inflation, it's now essentially just a meaningless number that isn't linked to any objective measure. And the court agreed. And part of the ruling is that the government has to develop a plan to not only deal with the procedural barriers, but when it comes to the means threshold and the value, is they need to develop a plan that links the means threshold value to objective measures of poverty. So I think the most immediate one would be the food poverty line. So it won't necessarily say that they need to set it at a specific value, but that the value has to be justified by a link to an objective measure of poverty, which is definitely a positive development.
And I suppose also because one of the big issues when you would listen to a number of the recipients, they will say, for example, I've asked for money from a relative and, there would be money coming into my account. It doesn't mean I'm working. It simply means maybe one relative would have thought about me at the time and sent me some money in order to be able to buy something to eat.
Yes, that was another aspect of it, which is how the income or how a sufficient means was defined. So prior, the government didn't have any definition of income, and they refused to define what income is. So they essentially, through the bank verification process, were considering any inflows into someone's bank account as income. So like you said, if someone is in desperate need, for example, for a month, and they receive some form of charity from their family or friends, that would be counted as income, which again, the courts agreed with us in that that's an irrational definition, because income is, I think, what we traditionally understand it to be. So some form of income from either formal or informal employment, or they even cater for things like financial support. So say someone regularly receives an amount of money, that would be a basis for exclusion. But one-time payments shouldn't be. So income should be reliable and it should be consistent, which is something that court agreed with us on.
And there's also something, I suppose, advocacy groups have been talking about, and I think this would be a big one that you would have, watched as far as the ruling is concerned, is that the court now wants government to put in place, a plan in place, rather, to improve the value of this grant. Have they proposed on how do they begin to deal with this?
So they haven't prescribed a value for it, but I think part of the plan that, which was also what we were calling for, we weren't saying that we want the courts to define a value for government, but that there should be some plan to deal with value. So, for example, the other grants, child support grant, old age pension, cane aid, all of those grants have been adjusted almost annually for inflation since 2020, which is just an annual process that happens with them because they're considered on a long-term basis. So we know, for example, rising cost of living, rising inflation erodes the value of the specific grant, so it buys less food. So the plan is essentially just that the value needs to take into account the issues like cost of living increases, issues like inflation, so that on a longer term basis, the government can adjust that. Because the SRD grant was introduced in 2020 at 350, and it remained at 350 for 4 or 5 years until it was adjusted last year in April, but only then by 20 rands, which that 20 rand increase still was nowhere near sufficient to keep the grant at the same real value. So even at 370 now in 2025, it's buying way less goods than it did in 2020.
And Siyanda, as a final question then, what happens if they decide to, appeal this particular ruling? Is it something that you have factored in when it comes to some of these developments here?
Yeah, I think that's a potential outcome that could happen. Is it could be appealed, but I think that we had a strong case. I think the facts on the case and the proof and the evidence that we provided is strong, so we would be confident in that. And I think that the ruling is still very very instructive, because it's a lot of the findings on just the fact that a lot of these measures are unconstitutional and unlawful, I think will have massive impact even on the future designs of the grant or whatever comes after the SRD grant. I think that will be used as a precedent when it comes to the design of those.
All right, Siyanda, I appreciate your time this evening. Thank you so much for chatting to us. That's Siyanda Baduza, basic income researcher at the Institute of Economic Justice.